Good afternoon, everybody. I'd like to call the meeting to order. Welcome to the Assembly Committee on Legislative Operations and Elections. Madam Secretary, would you please take roll?
Assemblyman DeLong.
Present.
Assemblywoman Dickman.
Here.
Assemblyman De Silva.
Here.
Assemblywoman Gonzalez.
Here.
Assemblyman Hibbets. Assemblyman MacArthur. Assemblywoman Brittany Miller. Assemblyman C.H. Miller. Assemblywoman Monroe Marino. Assemblywoman Newby. Assemblyman Yeager. Chair Gorlow.
Here. Please mark Assemblywoman Miller absent, excused, and the other members present when they arrive. Before we begin, I'd like to do some housekeeping. As a reminder, please make sure all your electronic devices are turned off or in mute. If you wish to testify, please sign in at the table by the door and provide a business card to the committee secretary. And when testifying, remember to turn on the microphone and slowly state and spell your name for the record. Please state also whether you represent a group or an organization, and then turn off the microphone each time you are done speaking. If we have someone join us from Las Vegas, it's really important for them because we get feedback. So if there's anyone hiding in the corner. We do expect some courtesy and respect in our interactions during the meeting, even if we may not agree with each other's positions. And committee members will be using their laptops to view handouts and other documents, so please do not take this view as a sign of disrespect or inattention. And we're also going to take our items out of order. Today we're going to start with AJR 6. So I will open the hearing on AJR 6. This is a Assembly Joint Resolution that proposes to amend the Nevada Constitution to adopt the National Popular Vote Compact. Assemblyman Watts, whenever you're ready, please proceed.
Thank you very much, Madam Chair, members of the committee. For the record, I'm Howard Watts. I have the pleasure of representing Assembly District 15 in the heart of Clark County, and it's my pleasure to present Assembly Joint Resolution 6 for your consideration today. And it's a pleasure to be in front of this committee, and so close. I'll talk a little bit at a high level around why I felt it was important to bring this forward for your consideration. And then I'm joined by Eileen Reevy with National Popular Vote, who will provide some additional background related to the measure and its history and how it works, after which we will be glad to take any questions that the committee may have. So I've been a strong proponent of the National Popular Vote, and to me, I put it in the context of our continually evolving and improving democratic republic. And over time, we have expanded the franchise to various citizens in this country. In addition, we've expanded the ways that people can participate. We've created initiatives, referenda, ways that people can actually vote directly on enacting or repealing policies. That was something that came about around 100 years ago. Before that, there was no aspect or no option for folks to participate directly in policy making. We have also seen changes in the way that our U.S. senators were chosen. Originally, a lot of them were chosen by state legislatures, and we actually modified that process to provide that authority to the individual people, to the voters, to elect those U.S. Senate representatives, and not to have the go-between of electing the legislators who then made that decision. And to me, that is a kind of similar thread that connects AJR 6 with the National Popular Vote, which is, when I talk to folks, I wish that state legislature was the most important position that people thought of, that they vote for. But, the U.S. president is number one, and then Congress right below that, and our our representatives are elected directly by the people. Our U.S. senators are elected directly by the people. But the president is not. We have the Electoral College, and I will note that states do have the ability to determine how their electors are apportioned. And states currently have different ways of doing that. Some do it winner take all based on the outcome of that election in their state. Some do it by congressional district, individual congressional district. So we've already seen that there are different ways that states determine and manage how they would do that. This proposes that if enough states come together, we will be able to move towards a system where every vote has the same weight, which is, to me, one of the foundational principles. It maintains that equal representation that we have in the Senate, for example. Every state has 2 senators. But when it comes to electing the president, I believe that every voter's voice should have equal weight and equal consideration in making that determination. And the National Popular Vote Compact would do that. It would guarantee that one person, one vote in electing really the highest office in our nation. So that is why I wanted to bring this forward for your consideration. I think there's no better way to do this than to also send this measure to the people to decide how they think our president should be elected. And if we can get enough folks to get on board with this across the nation to ensure that whoever gets the most votes across the U.S. for U.S. president will be the winner. So with that, I'd like to pass it over to Ms. Reevy to provide some additional background.
Thank you. Good afternoon, Chair Gorlow and all members of the committee. My name is Eileen Reevy, and it is my pleasure to be here today to discuss with you what I believe is one of the most monumental election reforms that is going to come before you and that we will see passed in our lifetimes. As Assemblyman Watts shared, the National Popular Vote Bill will guarantee that the U.S. presidency is won by the candidate who wins the most popular votes in all 50 states and D.C. This law applies the fundamental American principle of one person, one vote to the one office that represents all of us, the U.S. presidency. When it is passed, for the first time in our nation's history, every vote for the president will be equal in every presidential election. Frankly, our current system of electing the president is not in the best interest of most, let alone all Americans. The shortcomings of the current system stem from the winner-take-all laws that Assemblyman Watts discussed. This is how states have chosen to participate in the Electoral College, which is why we're before the state legislature asking you to consider that constitutional duty of if what we're doing now is really in the best interest of all Nevadans. So currently, 48 states, including Nevada, have statewide winner-take-all laws that will award all of a state's electoral votes to the candidate who receives the most popular votes within that state. So because of these laws, 5 of our 46 presidents, 10% of them, have come into office without winning the most popular votes nationwide. Of course, we all remember this has happened 2 times in our lifetimes. In 2000, 537 votes in the state of Florida won the election for President George Bush. And in 2016, narrow margins in 3 states were enough for then-candidate Donald Trump to rightfully win the presidential election and the Electoral College under our current laws, despite losing the popular vote by over 2.8 million votes. Equally as important is realizing that this has happened almost an additional 2 times just in the first 20 years of this century. In 2004, if 60,000 voters in the state of Ohio had changed their votes, John Kerry would have won the state of Ohio, won the Electoral College, and got on to be the next president despite losing the popular vote by a larger margin than Hillary Clinton did in 2016. 115 million ballots were cast in that election, and 60,000 people in one state could have changed the outcome for the entire country. And of course, the other time that we were very close to this happening was in 2020. 5,200 voters in Arizona, 5,900 voters in Georgia, and 10,300 voters in Wisconsin won the election for President Joe Biden, not the 7 million voters who delivered him the popular vote victory. As a result of these laws, presidential candidates are only paying attention, really, during the general election campaign to voters in these states that happen to be closely divided in a presidential election year. And really, they're campaigning to this narrow group of undecided voters every 4 years, resulting in an election where every American's vote is not equal. This system is what gives us these close totals in a handful of states that are repeatedly resulting in controversy, uncertainty, recounts, and hair-splitting legal decisions. And honestly, a loss of confidence in our elections in some places. These are all problems of the current system, and they will be alleviated, not exacerbated, by passing national popular vote. So these winner-take-all laws, as Assemblyman Watts mentioned, it is not in the U.S. Constitution. It was never mentioned at the 1787 Constitutional Convention. It is not mentioned in the Federalist Papers. The U.S. Constitution, specifically Article 2, Section 1, gives states the exclusive control over the choice of method of awarding your electoral votes. This is a power the Supreme Court has termed a plenary and absolute power of the states, which means that there is a built-in way for states to reform the system. And specifically, Article 2, Section 1 reads, "Each state shall appoint in such manner as the legislature thereof may direct a number of electors." So those 17 words are what allow you to have winner take all and allow other states to use the congressional district method and for states to adopt national popular vote. So the national popular vote law will take effect when enacted by states with a majority of the electoral votes, which currently that number is at 270. When this happens, the presidential candidate who receives the most popular votes in all 50 states and DC will win the electoral votes from all of the enacting states, which will be a majority of the electoral college, meaning it's enough for them to win. So the candidate who wins the most popular votes nationwide will be guaranteed to win the electoral college. Under the national popular vote law, no voter is going to have their vote canceled out at the state level any longer because their choice differed from the majority sentiment in their state. Instead, every voter's vote will be added directly to the national count for the candidate of their choice. This will ensure that every voter in every state will be politically relevant in every presidential election, regardless of where they live or who they vote for. The National Popular Vote Bill also retains the power of the states to control how the president is elected, and it's within your power to work with other states to repair the Electoral College and improve the electoral system. So far, this bill has been enacted by 15 states and the District of Columbia, and we have 195 of the needed 270 electoral votes signed on. In previous years, we've also had a lot of success in other states. We've passed at least one legislative chamber in 9 additional states with 88 electoral votes, including Republican-held chambers in Arizona and in Oklahoma. Currently, this legislative session, Nevada, you are among 11 other states that are considering this bill with a total consideration of 160 electoral votes. So getting to 270 is not something that is decades away. It is something we can do by the 2028 presidential election if you are hopefully a part of that solution. Currently, we've got bills pending in Michigan and Minnesota, so even within just 2 more months, we could be at 220 electoral votes, so just 50 electoral votes away. So the way that we elect the president is frankly broken, and before you is a tangible constitutional solution that is already 72% of the way towards enactment. It's supported by over 3,500 state legislators across the country and dozens of national, state, and local groups. You should have in front of you this document which shows a lot of the supporters that we have. Among them, ACLU, League of Women Voters, NAACP, Brennan Center for Justice, Stand Up America. Represent millions and millions of members across the country that believe in the very basic American principle of one person, one vote, every vote should be equal. So I hope that you will consider this bill, and I am happy to take any questions that you might have. Thank you for your time.
Thank you. Howard Watts for the record. Now, we're glad to answer any questions that members may have at the pleasure of the chair. Thank you.
Thank you very much for your presentation. Committee members, are there any questions? Okay, Assemblywoman Dickman.
Thank you, Madam Chair. So my question starts with a little bit of a statement. Back in 2016, every major Republican candidate visited Nevada, small towns in Nevada. In 2020, I believe every Democrat candidate was right here in Carson City. As a result of some of those relationships, one of our very own senators is now an advisor to President Biden. So if this passes, do you really think that they will even bother with us in such a small place, such a small population, instead of going to the population centers?
Thank you so much for that question, Assemblywoman. Howard Watts for the record. That's a great question. And I think it's important to note a couple things. One is that we're talking about the general election. Nevada is poised to remain very close to the beginning of the presidential primary contest calendar. And that's going to drive a lot of attention and a lot of candidates to come to Nevada to make their case, because they're going to be looking to win this state and show that their campaign has momentum. And so I think we're still going to get all those candidates coming from both parties trying to win Nevada in a presidential primary. For the general election, again, we are still an area with close elections, with with undecided voters. We're still going to have close statewide races, including governor, including Senate, and those are going to be races that presidential candidates are going to want to come here and get involved in and support their preferred candidates in those down ballot races as well, so that they have support in Congress, so that they have support in state government. So I don't think that this is going to have a negative impact on the interest of presidential candidates here in the state of Nevada. And again, I think what this does is it actually opens up the playing field for folks to, I want them to come to Nevada, but you know what? I want them to visit every state at least once. And there are states that are completely ignored in this process. And I don't think that is appropriate. I think this will encourage a new system of elections where folks are going to go to every community and try and get every vote possible to make sure that they are victorious. And the last thing that I would say is, when we look at the system now and we look at how close Nevada is, and we had recent elections that get close on each side. Whoever is on that losing side in a presidential election, their votes don't matter. And and in recent presidential elections, it's been honestly the Republican Party. If the Democratic candidate for president wins here by one vote, the impact of all of those Republican voters and their preference is basically wiped off the map. And I think that this is a better approach.
Did you have a follow-up?
It's not really a follow-up, it's a different topic, so if you want to come back to me, maybe?
Okay.
Okay, thanks.
Then we'll go to Assemblyman DeLong.
Thank you, Chair. I appreciate you bringing up Article 2, Section 1, and stating that plenary power is with the legislature. And my concern with what's in front of us now is that we're looking at putting this into the Constitution, going through a 6-year process, which dilutes the legislative's ability to modify our position if, for some reason, we did pass this, and it turned out not to work, and we want to back out. And the AJR as written does allow for backing out, and we lose some of our authority, and that's concerning to me.
Thank you for that note. Howard Watts for the record. So I appreciate that you did note that the language does provide for withdrawal, and that actually does allow for withdrawal by statute. So it does maintain the legislature's power. Additionally, it's within the legislature's authority to propose an amendment to the Constitution, and to submit that amendment to the people for a final vote of adoption or rejection. And again, if we saw that it didn't work, we would have the option, if we wanted to remove it from the Constitution, we would be able to pursue that as well. So I think there are a range of options, and I just want to, and I believe that most of the members of the committee are aware, but just to put a finer point on it, the way this works is it does not take effect until we get to 270 electoral votes within the compact. So even if we pass this, I hope for great success across the country, but it's likely not going to take effect before the next presidential election, to be sure. And if there is some dissatisfaction with the outcome, again, there are a range of methods that can be pursued to exit it. And if there was general disagreement from other states as well, there has to be 270 electoral votes for it to take effect. So if other states withdraw and we drop below 270, unfortunately the compact would go out of, it would no longer be in effect.
Thank you very much for that answer. We'll go with Assemblyman Hibbets next.
Thank you, Madam Chair, and thank you for the presentation. It was interesting. During the presentation, you told us some great stories about the history of the Electoral College and the history of our elections, but not once in your presentation did you mention what's in this. And as you are asking us to alter the Constitution of this state, I was wondering if you might be available to spend a few minutes on what is in this document.
Howard Watts for the record. We'd be glad. It's my pleasure to answer. Do you have any specific questions, or would you like us to walk you through the language that is being proposed?
Well, in a general sense, could you walk us through? Obviously, I don't think you need to read the entire thing into the record, but I appreciate that. Just in a general sense, if you could walk through what this document does.
Howard Watts for the record. I'd be glad to. I'll turn it over to Ms. Reevy to walk you through it. But again, I think we attempted to cover that in the presentation, which is that this is proposing to have Nevada join a compact with other states, that all of those states would collectively agree to allocate their electoral votes to whoever wins the most votes across the entire nation. That it would not be effective until there were enough electoral votes within that compact to actually provide the electoral votes necessary for a candidate to win, and then that there is a provision for the state to be able to withdraw from the compact if they so wish. That's it at a high level. I'll turn it over to Ms. Reevy if she wants to give some additional details on the content of the measure.
Thank you. Eileen Reevy for the record. So we can just go section by section here. So section 1 just states that any state may join this compact. Section 2 is the right of the people within the states to vote for the president. This is so that if a state legislature were to say, we don't want the citizens of our state to vote for the president, we ourselves are going to appoint those electors. That is not a state that would be participating in the national popular vote total. They would be disenfranchising their citizens in many ways if they chose to do that. So a popular vote must be held for it to be a part of the national popular vote total. Section 3, a lot of this mimics some of the language that's already in federal law around presidential electors. So it states that the law will be that it is prior to the time set by law for the meeting and voting of presidential electors, the chief election official of each state is going to determine that the electors in Nevada are the ones won by the national popular vote winner. Again, it says at least 6 days before, fixed by law before the meeting and voting of the presidential electors. Each member state will make that final determination. This is something that is already required by federal law in the Electoral Count Act, which was also updated actually at the end of 2022 for only the second time in our nation's history. It also talks about in this same section that this important part that we must have 270 electoral votes committed by that July 20th date, so 6 months before the inauguration of the next president. So if a state were to join or withdraw from the interstate compact within that 6-month period, it could not take effect until after the next president is inaugurated. This is enforced by the Appointments Clause of the U.S. Constitution, and no state in the history of our country has ever removed themselves from an interstate compact without adhering to the terms of that compact. The other provisions kind of talk about when it will take effect, when states cumulatively possessing a majority of electoral votes have enacted the compact. Again, any state may withdraw. It does say that the compact shall terminate if the Electoral College is abolished. Section 5 provides definitions. These, again, are because from state to state, they have different ways of who is the chief the chief executive. Is it a governor? Is it the Secretary of State that's the person within that state that's responsible for making these determinations? And then the sections 14B at the end relates just to specifically tidy up some language related to your existing faithless elector law. So this next section is not a part of the 888 words of the Interstate Compact, but this is just mimicking the law that you already have, that a presidential elector shall cast their vote for the presidential slate nominated by the party that they are representing. And then the next section is what we were discussing with Assemblyman DeLong, that does not have to go back to a vote of the people for the legislature to remove themselves from the compact, that the state legislature holds on to the power to do that themselves.
You may.
Thank you, Chair. And actually, my follow-up is for Mr. Fernley. Sorry to bother you. Section 14B, subsection 2, the statute, or the state of Nevada may withdraw from the National Popular Vote Compact by statute. Can we as a body change the Constitution by statute?
Generally not, but if that provision were included in the Constitution, then the Constitution would be allowing you to withdraw from that particular provision by statute. So by having it in the Constitution that you can withdraw from that one particular thing by statute, the Constitution would allow you to withdraw from that one particular part.
Thank you very much, and thank you, Chair. And thank you.
Thank you. Any other questions? Oh, actually, I have one. We'll go with Assemblywoman Monroe Moreno first.
Thank you, Madam Chair. And thank you, Assemblyman Watts, for bringing this. This matter first came before me, I believe, my first session by Assemblyman Tyrone Thompson. And at the time, I thought, oh, no way, we can change the Constitution and go this way. But seeing what's happened in our country with elections and hearing from young people in our communities that we're encouraging them to register to vote and get involved, and then they see that sometimes their vote counts for my seat, it counts for the mayor of their city, it counts for the senator that they send to Congress, but it doesn't always count for their presidential candidate. It's kind of a hard story to tell why. So I wish I would have voted yes back then to have solved this problem, but thank you so much for bringing it back this time. I will be voting yes on this. I hope the committee members will join me in that, because we are a country where one vote, one person should matter. And whether we like to admit it or not, elections are a popularity contest. It's who reaches their constituents, who has a better message, who resonates with those constituents. So when they vote for that person, then their vote should matter. So I just wanted to say thank you. But my question, since this is an AJR, we would be hearing it this legislative session, and then it would have to come back for the next legislative session, correct?
Thank you for that. Howard Watts for the record. Yes, that's correct. So if the legislature were to pass Assembly Joint Resolution 6 this session, it would come back to this body again for consideration in the 83rd legislative session, 2025. It's hard to keep track of time sometimes, especially right now as we approach a deadline. And it would have to be passed again in identical form. At which point it would go on the 2026, it's a midterm ballot, so after the next presidential election, but before the 2028 presidential election for a vote of the people. And so if it was approved by a vote of the people in 2026, and then we also reach members of the compact totaling a majority of electoral votes, then it would take effect in 2028. And again, perhaps we get beat to the punch and states just rush the door to join this, but I think probably we're looking at 2028 at the earliest for this.
Thank you for that. So this ultimate decision will be the vote of the constituents that we all represent. We can say yes that we want it, but if the majority of our voters, when they go to their ballot and they don't vote yes for it, then we stay with what we have. But we entrust our constituents to cast their votes, to vote for us. So thank you for putting on the record that we can trust them to vote for or against this in 2026 to go in effect in 28 but thank you for putting that on the record. And thank you, Madam Chair.
Howard Watts for the record. Thank you very much for that. And again, I supported the last time this concept was brought before this body in 2019, I believe, by late Assemblyman Thompson. So I'm a supporter of the concept in general. I'll make that perfectly clear. At the same time, when I decided to bring this back, I thought that given some of that history that I've discussed about the expansion of the right to vote, and the breadth of that ability that is expanded. So not only who can vote, but how their vote is able to make decisions at state, local, and even federal levels. I decided that when I was going to bring this forward that I wanted this to be something that there was a popular vote on, that the people themselves would make the decision on how they think the President of the United States should be elected. And that is exactly what would happen. So I understand members are going to make their own decisions based on how they feel about the policy, but in my mind, ultimately, this is a decision about whether we want to send that to the people to decide how they think the President of the United States should be elected.
Okay, thank you. Let me ask my question first, then I'll come to you. Okay, thank you. I was sitting here, really enjoyed the little history lesson that you gave at the beginning of your presentation. I was starting to think back a long time ago, longer than I'd care to admit, for high school and U.S. history and government. We haven't always elected our presidents the way we currently do. In fact, I was thinking with the vice president, that used to be the person who was second place rather than the way we do it now. So can you refresh my mind a little bit about the history of how we have changed elections?
It would be my pleasure. Howard Watts for the record, and also Ms. Reevy, who's I'm sure studied quite a few of these issues, may step in to add or correct anything if I forget. But yes, originally when we held elections for president, the person who was runner-up was vice president, and that led to a couple of interesting administrations for sure. As folks who have watched Hamilton may recall. And yes, we actually changed the Constitution to provide for the election of the vice president and kind of leading to that ticket system, so that you didn't necessarily have a president and vice president of opposing parties. Of course, here we elect the governor and lieutenant governor separately, so there's a range of different ways to do things. Additionally, again, state legislatures originally determined U.S. senators for each state, and that was another amendment to actually provide direct election of senators by a popular vote. When we talk about expanding the franchise, of course, women, people of color, non-landowners, and then ultimately young people, 18 and 19 and 20, all were given the right to vote. In the 1920s, in the progressive era, the expansion of the franchise to initiatives to bring forward policy directly, which varies from state to state. Referenda, so to challenge a decision that a policymaking body brings forward and potentially repeal it, as well as recalls, which some of us in this body may be familiar with. Those were all brought forward to, again, increase accountability of our government to the people. And then, yes, in terms of the election of the president, as Ms. Reevy stated, the Electoral College is very clearly established. How the electors are selected is not. And so I will just say that in general, we have seen a continual trend of maintaining our democratic republic, right? People still elect their representatives, and those are the folks that are entrusted to use their knowledge and experience to make most of the decisions. But we have continually expanded the ability of the people to more directly select their representatives and hold them accountable. So if Ms. Reevy has anything to add, I'd pass it over to her.
Thank you, Eileen Reevy, for the record. The only thing that I'll add, the way that we elect the president now is nothing like it was at the founding of our country. At that time, governors were able to appoint electors directly, the state legislatures, and it was not until the 10th election for U.S. president that a majority of states used the winner-take-all law that we're all familiar with today. So it has been a constant evolution.
Great. Thank you very much. I'll ask the committee again if there's any other questions. Okay, we'll go back to you, Assemblywoman Dickman.
Thank you so much for a second chance. I just, part of my question was going to be why you went the AJR route instead of just a bill, but you kind of have sort of answered that. But since we're doing the history lesson, so when you mentioned that it was before this body before, was it a bill or was it a resolution, and what happened to it?
Thank you, Howard Watts, for the record. It was a bill. It was last before this body in 2019 during the 80th legislative session. It was passed by both houses of the legislature and vetoed by the governor, who I will say was a Democrat. So this is, in my mind, not a partisan issue, and I am not bringing this forward out of partisan politics. I know that there can be an analysis and debates about this from a partisan perspective, but I'd just like to make it clear that that is not the reason that is driving me to bring it forward. I think I've laid out the reasons why I'm passionate about the issue in the rest of my testimony.
Thank you. I was not here then, so I wondered what happened.
You're welcome. Go ahead, Assemblywoman Monroe Moreno.
Thank you for the second time. And you had said something about the way we elect presidents now was not how we did when the Constitution was made. And I'd like to remind everyone that we're a female majority, right? And when that Constitution was made, women could not vote. I could not sit here. And as a Black woman, I was just a piece of property. We as a country have matured. And we have expanded our election laws and voting laws to grow with who we are now. And this is the right time to make the adjustments that we've seen that there's problems with how we elect our president. That's what we do in America. We learn from our mistakes. And I thank you for bringing this back, that I can correct the mistake that I made.
Okay, any other questions? Seeing none, thank you very much. We will go ahead and start with testimony and support. So if you have, each person will have 2 minutes for testimony. Members of the public may provide it over the phone, also by calling 888-475-4499. And when prompted for the meeting ID, enter 825-4973-0321. We will come to Carson City first, and don't forget to state and spell your name for the record, and you may begin when ready.
Thank you. Christopher Pearson, Pearson. Good afternoon, Madam Chair, members of the committee. Thank you for holding this hearing. My name is Christopher Pearson. Until January, I served 3 terms in the Vermont Senate, and prior to that, 4 terms in the House. I have long worked with National Popular Vote. I'd like to use my time to point out flaws in what you will hear from opponents. Since they struggle to argue against the merits of National Popular Vote, they will try to muddy the waters, hoping to confuse busy legislators. For example, at Michigan and Alaska committee hearings, we heard there was no such thing as a national vote count. That would make this proposal difficult to pull off. Fortunately, there is arithmetic. Every state conducts a popular vote election and publishes results publicly. Federal law requires states to report them in a timely manner. The proposal in front of you depends simply on adding these totals together. Opponents say National Popular Vote will force a Secretary of State in one state to judge vote totals in other states. But Article 3, Clause 5 of the language you're considering today says, the chief election official of each member state shall treat as conclusive an official statement containing the number of popular votes in a state for each presidential slate. Opponents will say National Popular Vote can't work now that Maine uses a ranked choice ballot. But Nevada and other states won't have to wonder what the total is from Maine. After Maine concludes their rank process, the final round results will be published. There is no guessing or estimating. You may hear that passing this proposal will let California and New York control the outcome for the country. However, those 2 states only have 18% of the population, and the margin for Democrats coming out of those states is balanced by what Republicans get out of Texas, Florida, and a handful of other states. In short, we have answers to all of the objections you will hear and are glad to provide them. I hope Nevada will add to the 16 states that have already enacted National Popular Vote and help strengthen the democratic process for our country. Thank you.
Thank you. You may begin when ready.
Good afternoon. For the record, my name is Emily Prasad Zamora, Persaud-Zamora, and I'm the Executive Director of Silver State Voices that leads the Let Nevadans Vote Coalition, and today we're in strong support of AJR 6. Simply put, we believe that one person should mean one vote, and every vote should be counted equally. Nevada has made great strides over the past few years to modernize our election systems and ensure all voters have the ability to cast their ballots. Enacting the National Popular Vote Compact would strengthen Nevada's leadership in safe, secure, and equitable elections. We are hopeful that this will move forward, and we look forward to voters having a say in their democracy. And we thank Assemblyman Watts for bringing this bill. I urge your support. Thank you.
Thank you very much. Is there anyone else in Carson City who would like to come to the table in support of AJR 6? Okay, seeing none, we will go to Las Vegas. Is there anybody in Las Vegas who would like to come to the table in support of AJR 6? Okay, seeing none, broadcasting, we'll go to the telephone for anyone in support of AJR 6.
To testify in support of AJR 6, please press star 9 now to take your place in the queue.
Thank you, Madam Chair and members of the committee. My name is Christy Watson, Kristee, WATSON, and I'm calling on behalf of the Nevada Conservation League in support of AJR 6. For us, passing strong laws to protect our environment depends upon open and fair elections. Typically, we believe that the long-term health of our planet is inextricably linked to the health of our democracy. Nevada Conservation League supports Nevada joining the National Vote Compact to ensure each vote cast would have equal value, potentially as soon as the 2028 presidential election. We urge the committee to support this important bill. Thank you for your time.
Thank you for your testimony. Broadcasting, next caller, please.
Chair, there are no other callers to testify in support at this time.
Thank you very much. Okay, we will go on to hear testimony in opposition of AJR 6. We'll come first to Carson City. Again, you have 2 minutes, and don't forget to speak and spell your name, and you may begin when ready.
Yes, Yolanda Kanak, Yolanda. Last name is Knaak. I am going to first represent the Nevada Federation of Republican Women, and then after that, I want to have a chance to represent myself. I have a letter from the Nevada Federation of Republican Women. Dear committee members, our organization was formed in 1961 with 3 clubs and has been growing ever since. We now have 20 clubs statewide and more than 1,600 members. The Nevada Federation of Republican Women passed a resolution in 2019 to oppose the National Popular Vote Interstate Compact, and we do have our resolution listed at the bottom. The Electoral College balances the interest of high population and low population states, and without the Electoral College, the 4 most populous states, California, New York, Texas, and Florida, would decide the fate of our country, and thus the remaining 46 states, which we are one of, would have little control over their states' interests. Please vote no on AJR 6. And now, as representing myself, I would like to say that I believe that since there are, 4 large states that are very populated, what would really happen is we would never see any candidates for president or vice president come here. And if we do, it will be just minimal. And when whoever is elected president and vice president, they will be focused on pleasing the 4 large states. And, with them not coming here, we're not going to have the money here. And also with us not really getting the attention we need, the attention would go to the 4 largest states. And I think that this bill should be voted no on. Thank you so much.
Thank you for your testimony. Please go ahead when ready.
Thank you. Madam Chair and committee, my name is Lynn Chapman, and I'm the State Vice President of Nevada Families for Freedom. According to Andrew Morgan, MBA from George Washington University and a master's from National Defense University, quote, if the president is elected based on a plurality, then the minority would not have a chance of having their candidate elected. Only the concerns and interests of more heavily populated areas, such as the East and West Coast cities, would be represented. Interests in the minority and less populated areas would naturally be set aside and of little interest to future presidential candidates. Worse, the executive would be beholden and accountable solely to the majority, unquote. He further stated, quote, minority voter interests will no longer matter at the national level. Only the whims of the majority will. And the result will be precisely why Socrates opposed a democratic form of government. Once a majority is established, it finds a way to remain permanent, and the majority class will become oppressive to the minority class. There will be no means to overturn the majority, no matter how skewered the majority's view may be, unquote. Vote no on AJR 6. It's a very dangerous idea to put in our state constitution, and I've been fighting this since it first came to our state. Thank you.
Thank you for your testimony. Please go ahead, Ms. Hanson.
Madam Chair, members of the committee, my name is Janine Hanson. I'm the state chairman of the Independent American Party, and this body has reviewed this several times The first time was in 2009. National popular vote would reduce Nevada to a flyover state in presidential elections. National popular vote sets up a system of betrayal of the voters. Under NPV, Nevada voters votes in the Democrat presidential candidate, but the national popular vote winner is determined to be a Republican or an independent. The Secretary of State of Nevada will be forced to betray the voters of Nevada, certifying presidential electors for a candidate who did not receive the popular vote in Nevada. This kind of betrayal will infuriate the voters of Nevada and subject those who supported such a stealing scheme to the wrath of their voters. National popular vote will hurt Democrats as well as Republicans. NPV compact has no minimum percentage for a candidate to be declared the national popular vote winner. What this means is that in a three-way race, a candidate could win 35% of the vote or even less and be declared the winner. Up to 42% of Americans identify as independents. People are increasingly becoming disenchanted with both political parties. There are other third parties would also be deprive the majority parties of some of the national popular votes, including the Libertarian Party, the Independent American Constitution Party, the Green Party, and others. Because National Popular Vote Compact has no minimum percentage required of the national popular vote winner, we could elect a president with no national mandate. In 1860, when Republican Abraham Lincoln was elected, there were actually 4 candidates in the race. Lincoln received 38 of the popular vote. Stephen A. Douglas, the Northern Democrat Party, received 29.5. John Breckinridge received 18, and John Bell 12%. We know what happened with the election of Lincoln. He had no national mandate, winning with only 39% of the popular vote. The stark division in the nation that at that time resulted in a civil war and the bloodshed and death of 620,000 Americans.
Ms. Hanson, your 2 minutes are up.
Okay, I just have one sentence?
Yes, one sentence.
National popular vote creates instability, jeopardizing what the Electoral College has provided for over 200 years, the peaceful transfer of power. Please vote no.
Thank you for your testimony. Please go ahead when ready.
Good afternoon, Bob Russo for the record. I oppose AJR 6 of the National Popular Vote Compact being voted into the Nevada Constitution. It would give the electoral votes from Nevada to the winner of the popular vote in presidential elections. So if Nevada voted Democrat, but the winner of the popular vote was a Republican, all of Nevada's electoral votes would go to the Republican presidential candidate and vice versa. So essentially eliminate any type of representative government in the state of Nevada. I'll go on to say, too, that this compact does an end run around the Constitution and the true intent of the Electoral College by giving state electoral votes to the winner of the popular votes and essentially eliminating the roles and duties of state electors. This compact will give a say to the majority in large populated states in presidential elections and essentially eliminate the voice of those of us residing in smaller states such as Nevada. The voice of rural America will likely be eliminated in presidential elections. So I could see perhaps people in the rural states, they'll just say, why should I even bother to vote? I'm not being represented. So we're going to end up with both coasts representing the whole country and eliminating the whole middle part of America. I don't think this is a good deal at all. The other thing is, to my knowledge, no authority exists for determining the accuracy of the national popular vote for president. There could be disagreements between the states regarding who the winner is, while no national authority is in place to settle state disputes. The National Popular Vote Compact is not the answer. It undermines our representative republic, and I believe could eventually lead to a direct democracy, which James Madison describes unfavorably in Federalist Papers number 10. The Electoral College has worked well since the birth of our nation in providing a peaceful transfer of power. Why change something that has represented all Americans and has worked so well in the past? So I urge you to vote against this amendment. Thank you very much.
Thank you. Please go ahead when you're ready.
Hi, my name is Lisa Partee, P as in Paul, A-R-T as in Tom, E-E. I have nothing prepared. I just want to say ditto to everyone who's opposing this bill for all the reasons stated. I'm so against this. Thank you.
Thank you for your testimony, and ditto works too. So thank you. Please go ahead when you're ready.
Melissa Clement. Today I'm representing myself and my family. Nevada has always had an outsized level of power as compared to its population. And whether it's Harry Reid, Paul Laxalt, Pat McCarran, Ivana Kinsella. All of these people have got an outsized power that just doesn't make any sense. And why is that? That is because they have to come here. We have 6 electoral votes. Doesn't seem like a lot, but those 6 electoral votes make it so that my 3 children are like, they come downstairs to the living room and they're like, which presidential candidate is in my living room today? Think about that. I mean, we are just so blessed to live in Nevada. And I guarantee it won't happen in the future. It will be New York and Los Angeles and Houston. And you know what those areas don't have? They don't have mining. They don't have water issues. They don't have the things that make us fundamentally Nevadan. Now, here's the thing. You're representing us. And I can think of no good reason for a Nevada legislator to say, let's give our Nevada power away, because that is what you will be doing. The 4 largest metropolitan areas are New York, Los Angeles, Houston, and Chicago. They'll get a lot of play. Las Vegas is number 25, not going to get a lot of play. And then you go down from there. Reno is at number 82. This also, Assemblywoman Monroe Moreno, it works for the major parties because it gives both parties a reason to get very worked up about during the presidential cycle, because it's more exciting when we have more of an opportunity. And so I think it benefits all of us, but especially my children and me. So I'm asking you to vote against AJR 6. Thank you very much.
Thank you. Please go ahead when ready.
Richard Nagel for the record. This circumvents something that was, as Hamilton said, it prevents the tyranny of the masses, and it circumvents that. So we're throwing our power that we have to shape an election out the window by getting rid of this. I see no benefit to this, to being subject to California or New York or New Jersey. And that's just what's going to happen. We'll be subjects. We will be passed over for any grants, any money coming into the state from the federal government, because we will not count. And you're throwing that all away if you pass this. This is a lot of power. I mean, it's only 6 electoral votes, but it still gives us power. And this, if you get rid of that, that's gone, and we'll never get it back. So seriously think about what you're doing, okay? This may be an ideological thing that seems popular at the time, but remember, this has been around for 250 years, and we have a constitutional republic. We do not have mob rule, okay? So in that aspect, think about the constraints of what's happening, what's going on. We need to keep this intact and not depreciate or diminish it. Thank you for your consideration.
Thank you for your testimony. Please go ahead when you're ready.
Thank you. William Horn for the record. I'm going to point out some facts. Nevada can't alter the U.S. Constitution. The purpose of this resolution is to take the legislature out of the mix and force the electors to be appointed based on your formula of what you call popular election. The Nevada Constitution is subordinate to the U.S. Constitution. As was well read, Article 2, Section 1, each state shall appoint in a manner as the legislature may direct is part of the U.S. Constitution, not the Nevada Constitution. Any subsequent legislature will have the right to determine how the electors are going to be elected. You're wasting your time because you can't control through the Nevada Constitution the power that the U.S. Constitution gives to the legislature. And therefore, it's a bad bill for that reason. Further, Article 1, Section 10 says, "No state shall enter into any treaty, alliance, or confederation." What you're trying to do is enter into an alliance or some type of treaty with other states in order to get around the constitutional provisions, that is the Electoral College and the right of the legislature to control the manner of getting electors. Thank you very much.
Thank you for your testimony. Please go ahead when ready.
Betsy Strasburg for the record. This legislative body was elected to represent the Nevada Constitution as is. I always get concerned when there's so much effort to change the Constitution after the fact when it's not broken. I heard today enough states have come together. I do not want any compact to affect my vote. The sponsor said compact will allocate votes. Any allocation method is always subjective from my over 35 years of finance experiences. Unintended consequences. A person can pick up votes in every state and not win any state under this proposal, especially a spoiler candidate with hoards of money. If I recall correctly, Ross Perot won many votes and no electoral votes, which is designed to right size for the size of population in every state. Nevada will never be the most populous state. It's a desert. Nobody likes a desert. They like temperate climates. We are fine with the 6 electoral vote process. Since this legislature represents Nevada, please do not water down the impact of our vote in our state. Thank you for your time.
Thank you for your testimony. Please go ahead when ready.
Good afternoon, Joy Trushinsky for the record. Please vote no on AGR 6 to place the National Popular Vote Compact into the Nevada Constitution. The compact will make Nevada and other less populated states meaningless in presidential elections and do away with all of Nevada's work to become a significant state in the presidential election. Only 4 states, California, Texas, New York, and Florida, will decide who the president will be. The Electoral College was set up to protect small populated states from the larger populated states, to give the people in the smaller populated states a voice. Our founding fathers knew the importance of all states being counted in the major decision to elect a president of the United States. The national popular vote circumstanced the Electoral College in our U.S. Constitution and will destroy our status as a swing state. This would be horrible, not having a voice. Thank you for your time.
Thank you for your testimony. You may begin when ready.
Thank you, Madam Chair. I'm Sean Meehan, retired Air Force Master Sergeant, founder of Guard the Constitution. National popular vote has been one of my focus areas for quite a while. AJR 6 makes Nevada voters irrelevant. We've already talked about the big cities, so I'm not going to waste your time, but I want to reiterate, this runs in opposition to the presidential primary law and the intent that this body passed that Nevada is first in the West. NPV violates Article 2, Section 1, Clause 2 of the U.S. Constitution, the Electors Clause. Amending the Nevada Constitution requires a vote of the people. That vote removes the plenipotentiary control of this legislature. The U.S. Supreme Court opinion in Hawk v. Smith in 1920 clearly shows that this NPV amendment would violate this section of the Constitution. It also violates Article 1, Section 10, Clause 3 of the Constitution, the Compact Clause. Thomas Jipping, Deputy Director of the Edwin Meese Center for Legal and Judicial Studies, wrote, quote, "The NPV Compact requires congressional consent because it enhances the political power of compacting states at the expense of the non-compacting states. Although the NPV scheme would appear to retain the Electoral College system, it would be the cartel, rather than the states, that actually elects the president. Under the Presidential Electors Clause, we currently conduct 50 separate elections for president. Should fraud or tabulation errors occur within a state, those errors are contained within that state. NPV spreads such mistakes or fraud nationwide. A state legislature's power to decide how electors are appointed is delegated via the Constitution. Legislatures must comply with the purpose of the presidential elected system and the historical understandings around it. This Nevada legislature is creating a time bomb that will detonate in litigation after the first such amendment becomes ratified. States select presidents through electors with a sense of the people. And with respect to the sponsors, y'all need to take a look at Federalist 68 because you got some things wrong. Thank you, Madam Chair.
Thank you. Please go ahead when you're ready.
Casey Rogers for the record. You know I like to speak differently and frankly. And with everything that's coming through this legislation body right now, I see things a little bit differently. I got to sit in classrooms where kids were getting indoctrinated into left ideology. And with them coming out of college now and all the problems we're having in our current political lifestyles and situations and ideas, and the fact that kids don't want to work anymore, I really think that this is just part of this body's deal trying to get a socialist economy into the state of Nevada, especially medically.
Ma'am, can you put your testimony towards the
It is.
HRS?
It
Okay,
is.
Thank you.
I always say I speak differently than everybody else. Mine's a little bit different. This is my concern. So with all that happening, I just see everybody in the state voting one direction, and I think that's dangerous. And with all the good work that, Mike Lindell and Seth Ketchel and other people are doing currently on proving that Dominion machines are fraud machines, I would really consider
Ma'am,
this bill.
get to AJR 6.
It is AJR 6. Everything I'm saying has to do with it.
That has nothing to do with the bill.
I reclaim my time.
You don't
So,
reclaim any
do
time.
you
We can
learn-
move on very quickly.
Do you
Please
learn?
stick to the bill.
Do we learn from our mistakes? Look at Venezuela. So let's not all vote one way in our state. So absolutely, I oppose that bill because of everything I just said.
For the record, my daughter's been looking for a job and nobody will hire her, so she's in college. Just wanted to point that out, but please go ahead when you're ready.
Good afternoon. My name is Julie Burke, B-U-R-K-E. And I just, first of all, we're not a democracy, we're a constitutional republic. And I also heard the word selection, which was very disturbing. The electoral system was geniusly put in place by the founders so every citizen in the United States would have a vote that counts. Maybe some should go back and look at that. I also think that the states that are signing on to this compact or who have already signed on to it just happen to be blue states. And I want to say if there is so much concern for fair elections and the people's votes counting, where was the is the outcry regarding the past election fraud? Apparently, we're not supposed to mention the Dominion machines or the legal votes and signature verification, so we'll pass on from that. It just seems that the concern sways one way. And I believe this is a well-thought-out spin to manipulate the elections. This would never be accepted in sports, and it should not be accepted regarding elections. Thank you.
Thank you. Please go ahead when ready.
My name is Gary Bowman, B-O-W-M-A-N, from Minden, Nevada.
And I just don't have anything prepared. Just want to say dittos to everyone that's opposed to this SJR 6.
Thank you for being here. Please go ahead when you're ready.
Good afternoon, committee. My name is Jim DeGraffenried. I'm Nevada's Republican National Committeeman. I'm in opposition to AJR 6 on behalf of the Nevada Republican Party. We are opposed to AJR 6 as we have been in the multiple previous sessions where this has come up because we don't believe that it makes sense for Nevada to work so hard to be first in the primary election process and then be irrelevant in the general election. Nor should Nevadans surrender our voice to bigger states. I rarely have occasion to say this, but I felt that Governor Sisolak stated the issue very well when he vetoed this legislation in 2019, and I wanted to put the closing remarks from his veto message on the record. The governor said, while reasonable people may disagree as to whether the national popular vote should dictate the ultimate winners of presidential and vice presidential electoral contests, this is a notion that does not reflect the delicately balanced system of government that issued from the larger debate at the Constitutional Convention of 1787 between supporters of the Virginia Plan and those of the New Jersey Plan, in which the interests of small states were pitted against the interests of large states. The result was a compromise government that tempered the proposal outlined by James Madison's Virginia Plan, favoring large states by granting vast powers to a new federal government, with the proposal forwarded by New Jersey Delegate William Patterson, favoring small states by allowing each state to have one vote in Congress regardless of the state's population. This agreement, which when enacted would require a signatory small states' electoral delegates to vote in support of the candidates for president and vice president who win the national popular vote, could leave a sparsely populated western state like Nevada with a greatly diminished voice in the outcome of national electoral contests. Please protect Nevada's voice, join Governor Sisolak, and oppose AJR 6. Thank you.
Thank you. You can go ahead when ready.
My name is Mary Ann Humphrey. I do live in beautiful Carson City, Nevada, and I love it here. And I am opposing AJR 6. Okay, it's too many. There's too many. I'm sorry. I'm Italian. I'm talk with my hands. So anyway, I do oppose it. 92% of the people on Nellis do oppose it. And obviously, we have a greater amount of people here today voicing their opinions, opposing it. I would hate to see our elections be messed up. I just want to say I ditto everything that all the opposition has spoke on, so I don't need to repeat it. We need to maybe really correct the way our elections are handled with voter ID and not having ballot drop boxes and all that stuff, and go back to the way our elections were designed maybe 20 years ago. So anyway, I do oppose it, and I hope you guys will pay attention to what everybody said, because you guys are supposed to represent us and not do just what you want to do. Thank you very much, and please keep Nevada a beautiful state.
Thank you. We will go to Las Vegas now for testimony in opposition. Is there anybody in Las Vegas who would like to testify? Okay, seeing none. Broadcasting, we'll go to the telephones. Is there anyone who'd like to testify in opposition for AJR 6?
To testify in opposition to AJR 6, please press star 9 now to take your place in the
Hello, committee. My name is Leslie Quinn, and I couldn't find the room where this AJR 6 was at, so I'll do this on the phone. Please oppose AJR 6. This places the national popular vote compact into the Nevada Constitution. It would make Nevada a meaningless flyover state in presidential elections and do away with all Nevada's work to become significant in the presidential election. California, Texas, New York, and Florida will decide who the president is. National popular vote circumvents the Electoral College in our U.S. Constitution. We Nevadans, we deserve the right to vote, and we would appreciate you legislators to vote for we the people, not we the government. Please honor us and oppose AJR 6. Thank you.
Thank you. Broadcasting, next caller, please.
CYRUSHOJJATY. The bill presenter did not talk about why the Founding Fathers implemented the Electoral College, from the best of my knowledge. Correct me if I'm wrong. We should look and see why they did that system. It's pretty ironic how in 2016, news media outlets, I believe, called The Atlantic, talked about abolishing the Electoral College, while back in 2012, they said we should keep the Electoral College. What a coincidence. And yet these are the same people that talk about how we need to expand the Supreme Court, but several years ago said that, no, we should keep it at 9. It makes sense to have Electoral College so that people who live in rural states can have larger representation. If you look at Nebraska, if you look at Mississippi, the list goes on. And I don't really see how this system is racist. I mean, we have a lot of states that have a very high amount of power, like Hawaii, or even Nevada, with a very significant non-white population. So those few non-white people can really make a huge difference in the state. I really don't see us really having a democracy. What we really have in this country is really a corporatist system where a handful of wealthy elites and billionaires or whatever have enormous amounts of power. It's like a cartel, and just like this state to a lesser extent. Think about it. And before I yield my time, I don't really think the comments from Casey were really irrelevant. But anyway, thank you so much.
Broadcasting next caller, please.
Hi, my name is Katrin Ivanov, Ivanoff, like a Frank. The amendment of the U.S. Constitution that gave the people the right to choose our representatives in Washington and took it away from the state legislature is the reason we turned our election to a popularity contest. Our representatives in Washington are no longer accountable to the state legislators. Because of that, most of them do not listen to us, their constituents. They listen to the big donors because the more money they get, the more commercials they can put on TV, which guarantees them the next election. Hence, all of the laws that are protecting those big corporations that actually can vote to the expense of the people who are the actual voters, including those vaccine laws that protect the corporations. And even if your child dies from a vaccine, you can't even sue them. One of the presenters said, I quote, if the electoral college is abolished, end of quote. That shows me that this resolution is an attempt to create a slippery slope on the road to abolishing the electoral college. I also want to say ditto to everything that was said before me. Please vote no to this unconstitutional AJR 6. Thank you.
Thank you. Broadcasting next caller, please.
Good afternoon. Oscar Williams, OSCAR, WILLIAMS, Reno, Nevada, concerned citizen. I recall Mr. Watts testified that we are a democratic republic. My understanding is we are, in fact, a constitutional republic. I believe Mr. Watts has misled this committee in that regard, and he doubled down on that when he said that he was objective to the interests in his support of this bill, which clearly, hearing the testimony supported by other democratic states, or blue states, we should say, there's an issue here of Mr. Watts' candor to this committee. And I wish to recommend that he be brought up on ethics charges for lying to this committee.
Sir, you need to keep your testimony to the bill, and we are not disparaging members.
Very well. I yield my time. Thank you very much.
Thank you. Broadcasting, next caller, please.
Chair, there are no other callers to testify in opposition at this time.
Thank you very much. We'll come back to Carson City then. If anyone would like to come to the table and testify in neutral.
Thank you, Madam Chair, members of the committee. Gabriel DeCara, Chief Deputy Secretary of State for the record. I would just like to say that our office has no position on this bill. We will ensure that whatever the law is followed very closely. I would also like to put on the record that there's no evidence of any widespread voter fraud in the state of Nevada or anywhere else, and we are very confident in our election systems. Thank you very much.
Thank you. Anyone else in Carson City who would like to come to the table in neutral? Okay, seeing none. Doesn't look like there's anyone in Las Vegas, but Las Vegas, if there's anyone, come to the table now. Okay, seeing none. Broadcasting, is there anyone on the telephone who would like to testify in neutral?
To testify in neutral for AJR 6, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify in neutral at this time.
Thank you very much, Broadcasting. Would you like to come up and make some final remarks? You can. Nope. Okay, all right. Thank you very much. And with that, we will close the hearing on, I'm sorry.
Thanks, Madam Chair. And I just, I was thinking about in some of the testimony, there was references to the fact that this this violates the U.S. Constitution. So I was wondering if there was any chance that we could get the gentleman who said that back, and then maybe we could get a legal opinion?
I would rather just have a legal opinion. Would you like to? Please, thank you.
Yes, I can go through the issues that were raised, and I'll get an email out to the committee quickly. Yeah, thank you.
Thank you very much. Okay, with that, we will close the hearing on AJR 6. We will now move on to Assembly Bill 394. This measure provides revisions governing elections. Assemblywoman Newby, you may begin when ready.
Thank you, Madam Chairwoman. For the record, Sabra Newby, representative of Assembly District 10. I'm here before you to present a committee bill, AB 394, and it does two things. In Section 1, it requires that the Secretary of State develop a procedure to be used if the abstract or certification of results of any election is not timely prepared and transmitted as required. And these are the abstracts and certifications that are prepared pursuant to an election. So if that doesn't happen, this is a preparatory step so that the Secretary of State already has a procedure to follow in that case. And then in Section 2 of the bill, we see the second thing that the bill does, which is to require that the counting of ballots is only performed once. And there are exceptions to that. Two exceptions, an audit or a recount. As we all know, those are possibilities. And I know that saying it's a simple bill is the kiss of death, so I didn't just say that, but that is the presentation of the bill, Madam Chairwoman.
Okay, thank you very much. Committee, do we have any questions? Okay, we'll go with Assemblyman Hibbets first.
Thank you, Chair. Assemblywoman Newby, I know this is a committee bill, and obviously you weren't on the interim committee, so you may not be able to answer my one question, but when it comes to Section 2, subsection 3, and Section 3, subsection 3, which are the exact same sentence, except as otherwise required during an audit or recount, counting of ballots may be performed only once. Why?
I believe because the provision of the law allows for the ballots to be counted once, and they don't necessarily need to be counted multiple times, wasting resources. The exception, of course, is if someone wants to do an audit or a recount, but I will phone a friend. And that friend will be from the Secretary of State's office,
Yes.
who I believe is rapidly approaching.
Yes. Thank you. Please go ahead when you're ready.
Thank you for the question, Assemblyman. Mark Voloshin, Deputy Secretary of State for Elections, for the record. The discussion about recounts, repeated recounts particularly, is something that's come up recently, and really in the last 12 to 24 months. One of the concerns that we've seen across the country about multiple recounts is that really the more opportunities for an individual to touch a ballot, there become more opportunities for whether it's deliberate marking or inadvertent marking of those ballots that could otherwise jeopardize or invalidate the results initially gained through tabulation. So the idea is by limiting it, it's my understanding from the interim committee, I certainly don't want to speak on their behalf, but it's my understanding that this was intended to address that risk and reduce it.
Quick follow-up.
Forgive me, I wasn't afforded the opportunity to visit the county election department, so my understanding of certain procedures is a little limited, but electronic voting, we don't actually touch anything, is that correct? Or are you referring specifically to some, I don't know, a county that might want to do paper ballots?
Mark Voloshin for the record. So currently under Nevada law, Assemblyman, we also have mail ballots, and those mail ballots, we do have a statute, and you're absolutely right, that we're required to conduct a recount in the same way that the ballots were originally tabulated. So in the regards to the direct reporting equipment, the DREs, those are exactly like you say, but for the mail ballots and or also other paper ballots.
Thank you very much. I appreciate the clarification. Thank you, Chair.
Thank you. We'll go to Assemblyman DeLong.
Thank you, Chair. Specifically, wanted to ask a question about, I think it's section 1, subsection 3J, the procedures to be used, ... Why is that needed?
Thank you for the question, Assemblyman. Mark Voloshin for the record. So in regards to the original intent, again, I don't want to speak for the committee itself, outside of saying that this is an ongoing discussion about why is there a need for regulations. There's an increasing risk to these sorts of events happening. And a lot of the discussions that have occurred in the election sphere over really, again, the last 2 years have started to take on a preventative nature, trying to make sure that if something could happen, maybe we think about a way to address it in advance to ensure that there's a regulation or otherwise a means to address it.
May I follow up? Thank you. Since it's talking about not being able to do something in a timely manner, am I correct in assuming it's getting to the fact on whether or not the election can be certified within the required time frame? Is that what we're trying to get at here?
Mark Voloshin for the record. Again, it's my understanding that yes, that there are requirements, and certainly under Nevada law as it exists, the canvass by the Board of County Commissioners must occur no later than the 10th day after the election. For a general, there's other requirements, but yes.
So we never had this problem before we allowed mail-in ballots to be delivered after Election Day.
Mark Voloshin for the record. So this concern does not relate necessarily to mail ballots alone. This is a challenge that could have occurred even without, when it comes to the transmission of the abstract in these documents. These are documents that possess the information relating to the electronic equipment and tabulations as well, not just the mail ballot. So the document would have everything in it.
Thank you, Chair.
Thank you. You have a question? We'll go to Assemblywoman Dickman.
Thank you, Madam Chair. I appreciate you guys being here and all, but I'm still not understanding the impetus for this bill. What caused these to be necessary? And I know the question's been asked, but I just didn't understand the answer, I guess.
Phone a friends.
Thank you for the question, Assemblywoman. Gabriel DeCara, Chief Deputy Secretary of State, for the record. As Deputy Voloshin said, the conduct of our elections has changed in relation to mail ballots, but also as technology has advanced. But also, increasingly, there have been questions about the way we conduct the elections and why we conduct elections that way. People have, from the perspective of some folks in the public sphere, have tried to get around the laws and regulations where there were previously not questions. So again, some of these questions weren't asked before, and it is the legislature has the right to create the statute and inform our office how we should conduct the elections, and the legislature saw fit to bring this bill forward, and so we will, again, do whatever it is the legislature asks of us. Thank you.
Quick follow-up?
Go ahead.
I'm just, when you say people have tried to get around, are you talking people in election offices like registrars, or? I hate to be dense here, but I just don't understand things.
No, ma'am, I absolutely understood, Assemblywoman Gabriel DeCara, for the record. So again, I was not serving in the Secretary of State's office during the time of the last election, but I was reading the news very closely, and there were a lot of people asking questions about what the law is and why the law is. Any number of news organizations had a number of explainers about how and why Nevada conducts elections the way that it does. And I believe, based on the existence of this bill, that the interim committee found that there needed to be some additional guardrails put around the conduct of those elections. And so, again, this comes from this body. Yeah, absolutely, Mark.
Mark Voloshin, for the record. Very similar to this situation, there was a situation they had in 2022 where one county in particular almost did not meet the canvass deadline. That 10th day after the election, the canvass must be conducted by the Board of County Commissioners no later than midnight on the 10th day. As we approached, it was almost 10:30 that night, and I was deep in discussion about what would that look like, and should there have been guardrails very similar to what Chief Deputy DeCara just mentioned a moment ago. So I do believe that this is a continuation of those sorts of discussions, trying to be preventative to make sure that the voters' will is heard and transmitted in the appropriate manners, so as to not risk jeopardizing an election.
Thank you, Chair.
You're welcome. Committee, go ahead, please, go ahead, Assemblywoman.
Thank you, Madam Chair. So just to make this simple, would it be fair to say that this bill is a response to things that were heard, to be more proactive in protecting votes and the process and addressing problems that we're seeing in previous elections? So it could be seen as a voter protection bill, a voter safety bill, to not clean up our system, but just tighten up the system.
Thank you, Madam Chairwoman, through you to Assemblywoman Monroe Moreno. I think you're exactly right. Sometimes we do things in reaction, but sometimes we want to be a little bit more thoughtful and not reactive and prepare. And this is an area where we don't have regulations, and so just in case we need them at some point, it's always better to be prepared than unprepared.
Well, I thank you and the interim committee for doing the work to look ahead and try to foresee problems that may not have happened, that could happen, and we already have a solution for those. So I appreciate you bringing the bill.
Okay, thank you very much. Any other questions? Okay, go ahead.
Thank you. So would these regs go to LegCom? Okay.
I believe so. Mr. Fernley, if you wanted to.
Yes, they would. All regulations are required to be submitted to the Legislative Council Bureau and submitted to the Legislative Commission unless there's an exemption from that, and there is no exemption for these regulations. So yes, they would go through Legislative Commission.
Thank you very much. Okay, committee, any other questions? Okay, seeing none, thank you very much. I'll go ahead and open up testimony in support of AB 394. Please come to the table. You have 2 minutes. Speak and spell your name slowly for the record, and you may begin when ready.
Chair Gorlo, members of the committee, my name is Isaac Tenorio, I-Z-A-C-K, Tenorio, T-E-N-R-I-O. On behalf of Campaign Legal Center Action, a national nonpartisan nonprofit organization that works to protect, strengthen American democracy across all levels of government, we respectfully urge for you to support AB 394 to protect the election administration and certification process from partisan manipulation and ensure that it runs smoothly, efficiently for the people of Nevada. Nevada law is currently silent on the appropriate course of action, and should a county or city board fail to timely certify the results, thus they would leave a gaping hole in the current code. By requiring the Secretary of State to establish procedures in these circumstances, this will prevent partisan officials from creating doubt about the validity of the election results. It will ensure that the Secretary of State is able to timely certify the state's election results and meet crucial deadlines by the federal safe harbor deadline that governs presidential elections. Furthermore, by specifying that outside standard audits or recount, the ballots may only be counted once, this bill will prevent unreliable partisan investigations from undermining confidence in the election process. Nevada's standard post-election audits have worked for decades and include important safeguards to ensure reliability, transparency, and accuracy. Most ad hoc audits lack these safeguards and do irreparable damage to the public's trust in election administration. It is vitally important to ensure the process for election administrations, especially those that occur in the crucial period after which voters have cast their ballots but are awaiting final results. We are clear and not open to, we want to ensure that our elections are clear and not open to exploitation or manipulation by partisan actors. For this reason, the Campaign Legal Center Action respectfully urges the committee to support AB 394 to protect post-election process to ensure that Nevada has a current and fair election. Thank you.
Thank you. Please go ahead when you're ready.
Good afternoon, Chair Gorlo and committee members. For the record, Emily Prasad Zamora from Silver State Voices, and today we're in strong support of AB 394. The last few years have taught us that anything can happen, and AB 394 ensures that Nevada is prepared for any scenario. It is common sense to have procedures in place should election results are not officially certified on or after the 10th day after the election. We also support the language that the counting of ballots can only be performed once, excluding audits or recounts. Both these policies ensure that Nevada's elections are certified in a timely manner. Thank you so much.
Thank you. Is there anyone else in Carson City who would like to come to the table in support? Seeing none. Las Vegas, is there anybody there? Seeing none. Oh, we do have someone. Thank you. Please state your name
Sorry about
for the
that.
record. You can go ahead when you're ready.
Good afternoon, Madam Chair and committee members of the committee. My name is Kerry Durmick. That is Kerrydurmick. I'm the Nevada State Director at All Voting is Local Action. We are an organization whose mission it is to fight for policies and legislative priorities that expand voter access. And we are also a proud member of the Let Nevadans Vote Coalition. We are here in strong support of AB 394. In the summer of 2022, I started working with local activists in Nye County after the Nye County Commission started the process of transitioning their election system to paper ballots and hand counting. When voters showed up in Nye County on the first day of early vote, many voters were confused to learn that they had to request to use a voting machine instead of freely being given the option. Nye's transition to hand counting and limited machines caused confusion among their voters. Nevada's elections are not an experiment, and they should not be treated as such. AB 394 would guarantee that the Secretary of State's office could adopt a procedure to be used if the certification of results for any election that is not timely prepared, and make sure the counting of ballots can only be performed once, except, of course, during an audit or a recount. We strongly encourage you to support AB 394, and I thank you so much for your time.
Thank you so much. Please begin when you're ready.
Good afternoon, Chair and members of the committee. For the record, my name is Aria Flores, A-R-I-A-F-L-O-R-E-S, and I'm here on behalf of Chispa, Nevada with the Let Nevadans Vote Coalition. We are in support of AB 394. AB 394 reassures our fellow Nevadans, our Our fellow Nevadans are a part of our electoral process. Just last year, we saw several counties across the state bring forth anti-democracy resolutions that only serve to obstruct and interfere with our electoral process. Multiple methods of counting ballots not only creates delays, but it also increases the likelihood of errors and confusion, and would further spread disinformation about our certification process in our state's elections. AB 394 is a clear and effective procedure to strengthening our statewide electoral systems for an effective and secure count. I encourage you to support AB 394. Thank you for your time. And then on a personal capacity, I would just like to also, for the record, Ari Flores, mention, preventative care or preventative actions always better than reactive action. And as previously mentioned, counting ballots at 10:30 o'clock at night is not effective for anyone. And so anything that is preventative should be taken into consideration. And so, on a personal capacity, I support AB 394. Thank you.
Thank you. And is there anyone else in Las Vegas who'd like to come to the table and support? Okay, seeing no one. Broadcasting, is there anyone on the telephone who would like to come in support of AB 394?
To testify in support of Assembly Bill 394, please press star 9 now to take your place in the queue. Caller with the last number 698, please press star 6 to unmute your phone. Chair, there are no other callers to testify at this time.
Thank you very much, Broadcasting. With that, we'll move on to testimony in opposition. Is there anybody in Carson City who would like to come to the table in opposition? Okay, seeing none, we'll go to Las Vegas. Is there anyone in Las Vegas who'd like to come to the table to testify in opposition of Assembly Bill 394? Please go ahead when ready.
Yes, my name is Mark Kampf. I'm the Nye County Clerk. Nye County in 2022 tabulated all of their votes using paper ballots with a tabulator, and we use that as a methodology for counting our ballots. We also performed a parallel hand count of those ballots, and we learned a lot through that process. We learned that the machines don't always count a vote that should be counted, but we also learned that the tabulation process did give us effective results. As a county clerk, I believe that I should be given the right to be able to check the results of that work prior to sending that off. We ask for audits of our state boards. We ask for audits of our counties. There's no reason why I should not be able to do a self-audit so that I have confidence in that vote. It doesn't need to be a complete hand count, as we learned, but I would like the ability to be able to do that audit. If there's a concern about touching the ballots and putting marks on ballots, I think we should then look at how many people are touching ballots all over the state, because believe me, there are election workers that are touching ballots with their hands through the tabulation process everywhere you look. So that really is not a concern. We wore gloves, we used purple pens, we did everything we could according to the state regulations, and we were able to do an effective job in learning about the accuracy of our vote. And I strongly oppose that provision of this bill. I do support the provision that provides for procedures in case the canvass is not done on time. Thank you very much.
Thank you. And is there anybody else in Las Vegas who would like to come to the table in opposition? Okay, seeing none. Broadcasting will go to the phones for anyone who might be calling in opposition of AB 394.
To testify in opposition to Assembly Bill 394, please press star 9 now to take your place in.
Hi, my name is Katrin Ivanov, Ivano Frank. I participated in the recount in Nye County for the 2022 election. We had to wear special gloves and use purple pants. Everything was done on camera. In case of some accidentally marked the ballot, the purple pen was obvious and didn't change the original intent of the ballot. If the timing is the problem, then we should go back to no mass mailing ballots and voting in our precincts. We had the results that very evening. Instead of making new laws that will have new problems, we should go back to the ones we know work. And we know they work because we have received our election results within a few hours of closing the polls. For many years prior to, previous legislators sneaked in election changes in the nick of night without putting much thought to it. That is why we have problems with the elections now, not because of anything else. Ballots counted once only guarantee that mistakes will not be caught. This bill does exactly the opposite of what the presenters and supporters of this bill are presenting they want to accomplish. On top of that, they mentioned that people counting at 1 a.m. at the nick of night, which guarantee that we have some very tired people that are counting, and one-time counting will almost certainly guarantee that mistakes will happen, not if they happen. Thank you, and I did what Mark can say. Bye.
Thank you, caller. Broadcasting, is there another caller who would like to testify in opposition of AB 394?
DYRUS, HOJJATY. I will ditto the previous two speakers. Yield.
Thank you very much. Broadcasting, next caller, please.
Chair, there are no other callers to testify in opposition at this time.
Thank you very much. We'll move on to testimony in neutral. Carson City, is there anyone who would like to come to the table to testify in neutral? Okay, seeing none, we'll move to Las Vegas. Las Vegas, is there anyone there that would like to testify in neutral? Okay, seeing none. Broadcasting, is there anyone on the telephone who would like to testify in neutral?
To testify in neutral for Assembly Bill 394, please press *9 now to take your place in the queue.
Hello, Oscar Williams. I didn't get in the queue early enough to vote it or voice opinion in opposition. May I take an opportunity to oppose this, please?
Go ahead and testify in opposition. We will reclassify.
I appreciate that. Thank you very much. This bill restricts valid complaints and demands for recounts and methods of recounts. It enshrines lack of transparency, and with that, accountability. This is accountability. Voter trust that when people do things wrong, our elected officials and our the people who run our elections don't comply to the law properly, and there's no recourse. That hurts our confidence. And this bill kind of puts steroids on that whole thing, all right? We have a right to individually, let's say, a ballot initiative for, let's say, ranked choice voting that was up in 2022. Anybody can complain and demand for a recount of that, right? And in that, there is the state law, NRS 293404, point number 3, the recount must include a count and inspection of all ballots, including rejected ballots. It must determine whether all ballots as marked as required by law, so on and so forth. The point is inspection. Inspection. What does inspection mean? It's undefined. And when people file their complaints, demand for a recount of a ballot question, as they are allowed under statute, they get no response. They're delayed. They're They're rejected. Oh, you didn't respond in time. You didn't pay up in time. And counties won't tell you what the costs are. Mr. Voloshin has some understanding of this point, and maybe he can elaborate on it after the fact. He can respond to me personally if he likes. But I'm concerned that this law enshrines a certain little system where that coincides with the other law of Canvas, which says that the shall take into account of the changes resulting from the discovery of a clerical error.
Mr. Williams,
so
you're
the
at
result
2
shall
minutes. Can you
be
wrap up,
declared to
please?
represent the true vote cast. So when you put it all together, madam, when you put it all together, this bill limits the public's ability or the county's ability to investigate.
Okay. Next caller,
concerns
please.
about election integrity.
Broadcasting next caller, please.
Chair, there are no other callers to testify in neutral at this time.
Thank you very much, Broadcasting. Okay. Would the sponsor like to come back up? I guess you weren't presenter.
Thank you, Madam Chairwoman, and thank you for the opportunity to present the bill. I just wanted to thank the Secretary of State's office and in closing say that, Nevada is known as one of the states that really does elections very well. And I believe that 394 has just a couple of tweaks that can even strengthen that process for us, and it makes sense to me, and I urge you all to support. Thank you.
Thank you very much, and we appreciate you presenting the interim committee bill. Okay, and with that, we will close the hearing on AB 394, and we'll move on to our next item on the agenda, which is public comment. I was going to say public testimony. It's late. My head hurts. This is the last item on our agenda. Again, each person has 2 minutes to provide public comment. Written public comment may also be submitted to the committee up to 24 hours after the meeting. Is there anyone in Carson City who would like to come to the table for public comment? He's seeing none. Las Vegas, is there anyone who would like to come to the table for public comment? Seeing none. Broadcasting, do we have anyone on telephone who would like to provide comment?
If you would like to provide public comment, please press *9 now to take your place in the
T-Y-R-U-S, H-O-J-J-E-T-Y. I respect opinions of people from wherever they come from. Much of this urge to change election laws is a result of the presidency of Donald Trump. And I respect your opinions if you don't like them. It's fine. But we have to figure out, why did he get elected? Even though I don't agree with a lot of things he does. Was it racism? Was it Russia? No. We need to address the voters. Fact is that many of the issues were ignored. This country, since John F. Kennedy got assassinated, has been going through a downward slope. The presidents after him have been pretty dismal. Not to mention the politicians that we've had in the state, whether it's the Reeds, the Enzymes of the world, constant warmongering, one-sided trade deals, mass immigration, selling out to Wall Street, Federal Reserve, growing income inequality, the destruction of the family, the list goes on. We were promised hope and change under Obama. Yet, if he was so great, the rise of Bernie Sanders in 2016 would have not happened. And yet, those frustrated voters ended up getting Donald Trump elected. I think you all should start looking into this. And remember, the same establishment, remember, we have a global cartel that has enormous amounts of power, that also has ties to the casino elites, unions, developers. They are responsible for the system and all the problems that has led to this. And we need to understand that the voters are concerned. They have a lot of frustration. And, just by pushing all these people around, it's not going to do it. We have to meet the needs of everybody. And I do think there's a lot of better candidates out there coming very soon. But other than that, food for thought. Thank you so much. Have a great night.
Thank you very much. Broadcasting, next caller, please.
Hi, Katrin Ivanov, Ivanoss for the record. I just wanted to make a comment. Please dig deep inside of you and please vote in a way that you bring trust in our elections back, not erode them. It's very sad that this beautiful country is losing trust in our way of doing things. In voting is one of the biggest rights we have, and people fought for it for a long time, including for women, including for black people. We've had it so good for so long, and now most of the people are not even trusting the elections, which is very sad. And one of the reasons is because you guys keep passing laws that make no sense. So please dig deep inside of you and listen to your conscience and to your constituents. Thank you.
Thank you. Broadcasting, next caller, please.
Chair, there are no other callers choosing to provide public comment at this time.
Thank you very much, Broadcasting. With that, we'll close public comment. Committee members, any final words? Okay, seeing none, thank you very much, and we will adjourn the meeting.